Top court-appointed receiver secret. Details matter. Introduction. I recently read an interesting case from the Court of Queen's Bench of Alberta involving a court-appointed receiver. To me, it highlights that sometimes the simplest of things can provide major difficulty. I will explain, but first I will go over some basic facts that will help you understand the issue in this case better. What is a court-appointed receiver? When a borrower defaults on its borrowing agreement, typically by non-payment, the secured creditor needs to decide if it is required to enforce against its security. The most common method for a lender to use is receivership. There are two types of these procedures in Canada. 1, private appointed. 2, court appointed. Normally, the procedure begins with the secured creditor seeking advice from its legal counsel and the receiver it is thinking of using. If it is chosen that there should be a receiver appointed, the secured creditor, normally a financial institution, then makes a selection. They can either appoint the receiver by private letter of appointment or make an application to the court for an order designating the receiver, court appointed. The Bankruptcy and Insolvency Act Canada, BIA, requires that just a licensed insolvency trustee, formerly called a bankruptcy trustee, can work as a receiver. A privately appointed receiver acts on behalf of the selecting secured creditor. A court-appointed receiver has a duty of care to all creditors. 1305402 Alberta Inc. versus 0774238 BC Limited. This case was an application by the court-appointed receiver as a British Columbia court-designated receiver of 2 individuals and also several companies to have funds in the amount of $281,711.11 paid to it in its capacity as the receiver. The application on its face seemed simple. The British Columbia Securities Commission, the Securities Commission, made considerable enforcement orders versus the individuals and the companies, the debtors. The total fines exceeded $9 million in total. They arose from the debtors having gotten from various parties real estate financial investments without a prospectus and various other violations. The Securities Commission got an order from the Supreme Court of British Columbia on October 3, 2019, appointing a receiver, the receivership order. The debtors are the named parties whose assets the receivership order covers. This application in the Alberta court was made by the court-appointed receiver to take possession of surplus cash paid into the Alberta court, available from the sale of a property located in the province of Alberta. The court's problems. On the face of the receivership order, it was difficult to tell which parties were originally served with notice of the case. The receivership order indicates that a list of those served was attached as Schedule A, yet Schedule A was not the service list. Rather, it was an example of the receiver's certificate to be utilized in securing financing of the receivership. There was also a Schedule B to the receivership order. Unfortunately, it also was of no help. Its only purpose was to list the legal description of the subject land. Counsel for the court-appointed receiver argued that certain findings in the original receivership application would decide the outcome of this case. As a result, the master said that it would certainly have been handy to understand whether the objecting party to this application had any type of capacity to make any kind of argument now. For example, was the matter in this application already decided in the original motion, or Are there any estoppel issues that would stop someone with notice of the original receivership application from objecting now? In the end, the master decided that the documents now before the Alberta court was not adequate to figure out those problems now. Duties of a court-appointed receiver. In addition to having a general duty of care to all stakeholders, the specific court-appointed receiver duties are spelled out in the receivership order. Like all such orders, this one gave the receiver the duty to take possession of all of the assets of the debtors. The funds in court are surplus from a sale or foreclosure in Alberta known as the Rocky View lands. There was a consent order for repossession in the foreclosure action, giving the mortgagee title. It was not readily evident from the material before the master just how surplus proceeds were generated. Nevertheless, the funds were being held by the court, and the receiver was applying to take possession of the cash under its receivership order powers and duties. The receiver's problem. The proceeds were paid into court on the application of the previous authorized owner of the Rocky View lands. Unfortunately, that owner was not one of the debtors. Just to make matters worse, one of the individuals who were one of the debtors filed an affidavit that appended a trust agreement. The trust agreement purported to state that the owner of the Rocky View lands was holding the property in trust for 19 different named investors who were opposing this application. The master held that the court-appointed receiver did not adequately prove its case to its entitlement to the funds paid into court. The owner of the lands was not one of the debtors. It was only the property of the debtors the court-appointed receiver had authority over. So the master decided that the court-appointed receiver could come back to court to establish that it has an interest in the funds after full argument by both the receiver and the opposing parties. It was too early to direct that the funds be paid to the court-appointed receiver now. The devil is in the details. From the master's decision, it is obvious that the court-appointed receiver came to court without knowing all the details. In addition, the details that it must have known about who was served with the original receivership application were missing. I am sure this receiver was not trying to pull a fast one over anybody. They were just sloppy. A detail like whose property was the receiver trying to take possession of is not a small thing. A detail like was any party who was opposing the receiver's request already stopped from raising such opposition is also not such a small thing. The master was correct in not allowing the receiver's application to take possession of the cash sitting in the Alberta court. The receiver will have to do its homework for when it comes back to court, when a full hearing is conducted. Top court-appointed receiver secret. Details matter. Introduction.